Hello. Again, good afternoon, everyone. And I should say, actually, good morning to our attendees from the West Coast. Welcome to our program, Does Your Website Comply with the ADA? Don't wait for a class action to find out. My name's Nick Reiter. I'm the co-chair of Venable's National Labor and Employment Practice Group. And I'm speaking to you today from our office in Midtown, Manhattan, New York. I'm joined today by my partner and co-presenter, Jean-Paul Carte, who often goes by JP. JP is a partner in our commercial litigation practice in San Francisco, and his practice focuses on litigating commercial disputes, often on a class action basis, including contract disputes, consumer class actions, and of course, ADA website accessibility claims. So first, before we hop into our program, just a few housekeeping items. You'll see there's a chat function through which you can submit questions. JP and I will try to answer a couple of those questions either during the middle of our program or at the very end, if there's time. But candidly, we don't expect that we're going to be able to get to everybody's question during the hour that we're together today. Not to worry, our webinar software, it allows us to grab your questions. And we're going to follow up next week with a sort of Q&A type document where all the attendees can see the questions that were asked. We can synthesize those questions for any overlapping questions, and JP and I will provide answers. And don't worry, the questions are anonymous, so please feel free to submit questions as the program is underway. Also, and I'll just go to our next slide here, for the folks in California, for the in-house in New York, and for anybody looking for CLE credit, our firm's going to follow up with all the attendees with a submission form for CLE credit. There's going to be a password, which we'll announce later on in the program, and it's important to hold on to that password because you'll need it for when you submit the CLE submission form. Now, I suspect a lot of you already, a lot of you who are attending today, you're already aware of the proliferation of website accessibility lawsuits over the last several years. And it's not really a secret anymore that these suits, they're really one of the new favorite toys of the plaintiff's bar. So today we're going to cover a couple topics and offer some practical advice about ADA website litigation risk and issues. The first thing we're going to do, and I'm going to turn it over to JP in a second, to give everybody a quick crash course on the applicability of the ADA to websites and other digital content and the different rules that are in place in different jurisdictions around the country. Second, after that, then I'll discuss some of the things that we've seen that really put websites at risk for facing an ADA website claim. And I'll also describe some relatively easy, low-cost, practical things that your organization can do to lower its litigation risk profile, especially when it comes to these serial plaintiffs or these professional plaintiffs, as I call them, who often file hundreds or even thousands of these lawsuits. Third, after that, I'll turn it back over to JP to discuss how your organization can reduce the risk of a copycat lawsuit, especially maybe after you've already settled one or two of these claims. The fourth thing we'll do is I'll discuss how your service agreements with your organization's web design vendors might be able to mitigate some of that legal risk in this area. And then finally, before we take any questions that we can answer at the end, JP will offer a review of the typical defenses to an ADA website claim. So with that, JP, I'll turn it over to you for our first slide.
Well, thank you, Nick. I appreciate the introduction. And we greatly appreciate everyone's time here today. We only have an hour, and so we're primarily going to try to be focusing on the practical advice and steps you can take. But before we get into that, about a 30,000-foot view of the legal landscape here. Part of why I that is because Nick and I will probably be giving you some bad news today. There is not a tremendous amount of good news in this space, unfortunately. And we want to make sure everyone understands why that is, so they understand why it's important to get ahead of these issues. And obviously, as Nick mentioned, these claims have proliferated in recent years. They are all over the place. When I handled my first claim about 8 years ago, I thought, oh, that's interesting. And obviously now they're everywhere. But some of our problems in terms of the legal landscape arise from the fact that the ADA is 31 years old. It was written before the e-commerce was the driver of the national economy. And so the ADA Title III in particular talks about places of public accommodation. Those are our key words when we're looking at what the law here says. The ADA has 12 examples of a place of public accommodation. Doesn't say anything about the internet, a website, any sort of virtual platform. So the problem we have is an old law and a new economy and how we're going to mash those together. That is often the kind of problem where you would look for regulatory guidance, but unfortunately, we really don't have that. In 2010, the Obama administration and the Department of Justice issued a statement in support of website accessibility. They started working on rulemaking. The Trump administration, Department of Justice tabled all of that. The Biden administration is bringing some of it back, and I think we'll have a renewed focus. But that ping pong effect as we move from administration to administration means that we really don't have a lot of regulatory guidance. Nick is going to talk a bit about some of the specific problems with websites that trigger a lot of these claims. He's going to mention something called WCAG or YCAG. Anyone who's looked at this issue is probably somewhat familiar with YCAG. But one thing I want to make clear on is that it's not a legal standard. The legal standard is reasonable accessibility. YCAG is the only tool we have. It's a consortium industry group that has come up with it, and it has no legally binding effect, even though every single settlement I've done has talked about YCAG and mandated some sort of YCAG approval or assessment. But the other problem we have is that YCAG is a set of guidelines. It's not a binary, you comply, you don't comply. There's really no way to do that. So it's on a sliding scale of how close you are to meeting the YCAG objectives, which often unfortunately means that you're never, can never really be assured you're not going to get hit with one of these claims. So this is an issue where regulation is not necessarily a bad thing for business. It's somewhat paradoxical in that way. Ambiguity is what's bad for our defense clients. Ambiguity combined with some bad court opinions is very problematic. And then you add in a statute that provides for attorney's fees, and that's why we are where we are on this. So in terms of what the law says regarding whether or not your website must comply with the ADA, the law is mixed, and that creates problems for everyone. There's circuit by circuit variances, and what we really have is a spectrum. Some circuits and some courts are going to say, yes, your commercial website must comply with the ADA. Some are going to say no. The middle ground, which is considered to be sort of the most common approach, is what's considered the nexus approach. The nexus approach says that a website is not a place of public accommodation, a brick and mortar store is. But if a website is not accessible, you've lost some access to that brick and mortar store. And so there is a violation, or could be a violation. What we kind of tend to see here is on the no side of things. No, your website does not need to comply with the ADA. There's not a lot of good case law out there for you. There's a recent 11th Circuit opinion that will probably stop the Florida cases in their track. That's been a very common venue. There's some rulings out of the 1st and 7th that seem to say any website that's commercial is fair game. And the 3rd, 6th, and 9th, in particular, the 9th is an important one because it's California law that's relevant, follow that nexus approach. Many jurisdictions, the circuit courts haven't even weighed in. The 2nd Circuit is one of those. In New York, you have some district court judges that have said, have found liability. You have some judges who have said the ADA does not cover websites at all. So you have variability from judge to judge. This has led to a tremendous amount of forum shopping. I'll give you one example in particular. The 3rd Circuit has had an opinion out for a long time that most people assumed meant the 3rd Circuit had a nexus requirement. There is one judge in Pittsburgh, in the Western District of Pennsylvania, who went the other way and distinguished that case and really said, I think the ADA applies to all commercial websites. That particular courthouse assigns all ADA cases to that particular judge. So what we see now is California law firms hiring local counsel at Pittsburgh and filing there because they know exactly which judge they're going to get and they know which rulings are going to be followed. And what this means, I think, for a lot of you is, look, if you're doing e-commerce, you arguably open yourself up to lawsuit anywhere. You don't have the benefit, unfortunately, of deciding where you're going to get sued. If you have brick and mortar stores and the claim is based on a nexus theory, then you don't need to look 50 states here. You can look at primarily where it is that you're doing business. But what our strategy and what our advice to clients typically is you should plan and prepare for the worst, for the laws and the judicial opinions of the worst district out there or the worst state out there, because you never know really where you're going to get sued. Real quickly, talk a little bit about a couple state laws that I think are important to keep in mind, especially if you have brick and mortar stores in California. So the ADA allows for attorney's fees, and that's the huge problem here, but it doesn't allow for damages. The California Anti-Discrimination Law, the Unruh Act, allows for $4,000 in statutory damages. So it's a hugely popular and compelling piece of legislation for the plaintiff side to focus on. But California and the Ninth Circuit are going to have that nexus requirement, which can be very helpful for you if you're only doing e-commerce, if you don't have stores in California. As a result, we've seen, I think, a decrease in the volume in cases in California, and we've seen an increase in some other popular venues like New York, Pennsylvania, for example, Massachusetts. New York, likewise, has a state anti-discrimination law that provides some other hooks for monetary relief. So if you're doing business through brick and mortar in either one of those locations, we're going to want you to take a particularly close eye on this, because you may be a more attractive target to the bounty hunters. And so the bottom line here is that the law is very complex. There are mixed results. There are completely flatly inconsistent results within the same district courts. And whether or not your website needs to comply is going to depend on where you get sued. Hopefully, if you're in a nexus jurisdiction, the type of business you're doing, but it could just be the luck of the draw. It really could just be which judge gets assigned to your case. And for that reason, the position that I always take with clients is that money spent on remediation efforts and for increasing the accessibility of your website is always going to be money that's well spent. And then Nick is going to talk through this.
Thanks, JP. Let's go to our next slide here. So what puts a website at risk for an accessibility claim in the first place? And to answer that question, I really ask you to consider, what does the typical plaintiff look like in these cases? You know, if between us, JP and I, we've handled hundreds of these matters, some of them actual lawsuits and some of them just demand letters that we can resolve or push back upon from plaintiffs' lawyers. But I personally can only think of 2, maybe 3 out of those several hundred matters where I got the impression that the plaintiff was really primarily concerned with improving the accessibility of the website and not just focused on, you know, a quick payday. And you know, I'm not proud to say that, but that's just been my impression of handling that many matters. Most of those plaintiffs are looking for an easy target defendant. They're looking for a website where there's a lot of problems, a lot of access barriers, and where it will be relatively easy to convince that defendant to settle quickly instead of litigating the claim in court. So when that professional plaintiff or serial plaintiff who's hooked up with a lawyer and filed dozens or hundreds of these cases already, when they're combing the internet looking for easy targets, they're looking for what I call the low-hanging fruit. And here's a list of those items that you and your organization should be on the look for. First, it's a big red flag if your site doesn't have an accessibility statement. Every site should have a concise statement about the accessibility of the site content, the organization's dedication and efforts to making its content available to vision impaired and hearing impaired and other disabled site visitors. It's a pretty easy thing to do. It's something that you could even do today, probably, if you consult with counsel and you want it and your site doesn't have one. And it's nice to have it up there. It's also, though, a red flag if a plaintiff's attorney or the plaintiff doesn't see that when they're visiting the site. Second piece of low-hanging fruit, your video content. Really all or at least most of your video content on your site should have captioning. And if it doesn't, well, that's a really easy thing for the professional plaintiff to quickly pick up upon. You know, it doesn't take a big full-scale audit of a site to see that the video content doesn't have captioning. And if it's a hearing impaired visitor, they're not going to be able to access that content then. So I understand it's an expense and it's a little bit of a burden, but that is a big red flag if there's no captioning for video content. The third bullet here, broken links. What I mean by that is I'm sure, sometimes even yourself, whether or not you're vision impaired or hearing impaired, if you're just clicking through a site and you try to access a portion of a site, you click on a link and it says 404 error message or something to that effect. Well, that's frustrating, right? You can't access the content. But when you're vision impaired or hearing impaired or have another disability, it's even harder. It can create more access barriers, especially when the broken link relates to a way for helping disabled site visitors, such as the section of a page that might include a telephone hotline number for assistance to process a transaction. So it's really critical that you work with your web design team to ensure that there's no broken links. The fourth bullet here, and this might be the most important one, it's really the fourth and fifth bullet together. Your site needs to be screen reader compatible. There's software and even hardware that can help vision impaired visitors access the content. And it has to contain alt text descriptions. If it doesn't contain alt text descriptions for images on your site, so if there's a big picture of a Doritos bag for some reason on the site, there can be code that will tell a vision impaired screen reader, a vision impaired visitor's screen reader software, hey, this is a bag, an orange bag of Doritos. If you don't have that code, then that's something that most professional plaintiffs or any plaintiff and their lawyer, they'll quickly pick up upon that. And that's going to be front and center in either their demand letter or their civil complaint if they file a lawsuit. And it's going to create litigation risk for your organization. And screen reader compatibility and alt text imaging, that's not something your lawyers will handle. It's something that your web design team or your web accessibility consultant will be able to handle relatively easily. Last, the website, if it doesn't have an alternative means for consummating a commercial transaction, well, that's another piece of low-hanging fruit for a plaintiff and their lawyer that's likely going to be emphasized in a pleading or a demand letter. They'll allege in effect, hey, I'm vision impaired. I couldn't navigate the checkout page for your site when I was trying to buy a product, and there wasn't any information on the site about someone I could call, a customer service rep or someone as an alternative means of processing that transaction. And that's critical to what JP was talking about a second ago about the commercial activity element for the applicability of these laws in the first place. So if that's the low-hanging fruit, then how do we reduce that litigation risk? And the first and obvious one is to remove the low-hanging fruit. Again, think about what the typical plaintiff looks like. They're combing the internet, looking for easy targets. They're looking for sites that have all those low-hanging fruits that I was just describing. Because when a plaintiff sees a site that has all those defects, well, then they see dollar signs. They say, okay, this is going to be easy. We got them. On the other hand, when they see a site that doesn't have that low-hanging fruit, when they see a site that has already spent some time and energy, adding an accessibility statement, providing captioning for the video content, providing, front and center in a screen reader compatible form, a number for if someone's having trouble processing a transaction, a number for someone to call and speak to a person live as an alternative way of processing that transaction. Well, then what JP and I have been seeing over the last several years is attorneys and these professional plaintiffs, when they see that, they don't see dollar signs anymore. They say, oh, this is going to be hard. This is a company that's already spent some time and energy towards improving the accessibility of its website and digital content. So maybe we shouldn't send them a demand letter. Maybe we shouldn't file a lawsuit against them because we don't want a protracted legal battle and they're going to litigate and defend themselves against our allegations. The second bullet here, it's important to train relevant staff on accessibility issues. We typically recommend that our clients conduct that training at least once a year. This includes training your web design employees and staff and service providers even on what types of access barriers they should be on the lookout for and how those barriers should be remediated. And it also includes, though, training your customer service reps, what they should do, what they should not do or say when a customer calls them and indicates that they've had trouble accessing the site or maybe processing a commercial transaction as a result of their vision impairment or hearing impairment or maybe some other disability. The third bullet here, review of your vendor agreements. I'm going to talk a little bit later about how to negotiate some favorable clauses for indemnification and other reps and warranties. So I'm not going to get into it right now, but it should be on your list of ways to mitigate risk. The next bullet, end user testing and other audits. So what do I mean by end user testing? End user testing refers to a process whereby a disabled person will test the accessibility of your content. And that's, is under WCAG or other standards, that's really considered state of the art. That's one of the best ways to identify barriers and to stay on top of the accessibility of your digital content. But in addition to just being a good way to identify barriers, it's very effective for negotiating a very favorable settlement. When I have a client that's been conducting end user testing for however long now, and then they get another demand letter or they get a lawsuit, when I call up opposing counsel and say, hey, my client's already been doing end user testing and auditing its site, every 6 months or every 12 months for the last 2 years, 3 years, you got the wrong defendant here. We're gonna produce those results and show you that we've really been on top of this. More often than not, that signals then to the opposing counsel and the plaintiff, oh, this isn't going to be a quick, easy settlement. We have to either lower our expectations about what a settlement will look like, or maybe we even have to consider withdrawing the complaint because our allegations aren't going to be proven in the end. I'm going to go a little bit out of order here on the slide. I'm going to skip to the last bullet and just offer a quick comment about accessibility widgets. The boom in ADA website litigation over the last couple of years, it's not just on the plaintiff side. With that big uptick in lawsuits being filed, there's now this whole slew of vendors who sell services that are intended to improve website accessibility. And a lot of these vendors are good. A lot of them are very helpful. Some of them offer these little widgets that can be added to a website. They might be a little icon that you see in the bottom corner of the site. And a visitor to the site can click on the widget and sometimes the widget can adjust the display settings of the site content, adjust the font size, the color contrast, other things to improve the accessibility of the site. And look, those widgets, they're helpful. It's obviously better to have a widget than to not have any, remediation or any removal of website accessibility barriers at all. But they're not a silver bullet. In most cases, they don't fix everything. They certainly don't protect. You can't just say, okay, I put the widget on the site and now we're protected. The only way to really remove barriers and to insulate your organization from this litigation risk is to have humans often, or a very sophisticated AI program in some cases, where they can review the site content and they can remove barriers. A widget's not going to be a one-stop cure. Finally, getting to that second to last bullet, I want to comment on what I call the bronze, silver, and gold standards. Or some of my clients who are on this webinar have heard me say there's the Fiat standard, the Honda Accord standard, and the Rolls-Royce standard. And no offense to any Honda owners, I'm a Honda owner, so I can say that. A lot of times a client, will say to me, okay, Nick, we hired a consultant. They audited our site. And, we have a lot of content on our site. So they found 98 things that are potential access barriers. And then the client says to me, Nick, are you telling me we have to fix all 98 things? That's going to cost a ton of money. It's going to be a real headache. I don't even know if we can fix all 98 things. And the answer to the client's question in that scenario is almost always no. It's almost always no, you don't have to fix all 98 things. The ADA doesn't require that all access barriers be removed. There's an undue burden exception, and the law allows for alternative means to access. So fixing all 98 barriers in that situation, which would be that gold or Rolls-Royce standard, that's not usually what's required, and it's almost certainly not going to be practical. Your organization is just going to spend a lot of money fixing things that some of which might not create a lot of litigation risk in such case. Now, kind of at the other end of the spectrum, though, you shouldn't do nothing because that's very risky. And you probably shouldn't just fix one or two easy things, that bronze standard or Fiat standard, because that's risky too. For most of our clients, what we recommend is that you land somewhere in the middle around that silver standard. And that's where your outside counsel can really play a valuable role. Your attorneys can opine, kind of working in tandem with your web design team or your web accessibility consultant. Your attorneys can opine on the risks associated with each identified access barrier, and they can identify which barriers are worthwhile to spend some time and energy and money, frankly, remediating, and which barriers you can probably live with because they don't really present a lot of litigation risk. And also by involving your attorneys, you're bolstering the privilege that will attach to each of these communications, because you obviously, if there is litigation down the road, you don't want those communications to be discoverable. And by doing that, engaging in that process, both with counsel and your web team, you're going to be probably getting better bang for your buck in terms of the resources you spend towards remediation efforts. So now I'm going to turn it back over to JP to talk about how to reduce the risk of a copycat lawsuit.
Thank you, Nick. So these copycat claim issues end up unfortunately being a big problem that can be a real hassle for our clients and for defendants, even ones who are proactive about the issue and are working hard to try to fix it. There are only a handful of these bounty hunter law firms out there who do a large volume of cases. And unfortunately, they all look at what each other are doing. A bounty hunter from California is going to keep an eye on what someone in Pennsylvania is doing, look at who they're suing, and lo and behold, oftentimes, as soon as a case is filed, you get another case or you get some demand letters from everyone else. It's just a really easy way for the bounty hunters to track down potential targets. And so what is important to think of when you're getting a demand letter, when you're settling claims, is how do I put an end to this right here, right now, and hopefully not have it pop up again anytime soon. There's a big difference there between demand letters and complaints. It used to be for a while that everyone would just rush out and file complaints and then get the ball rolling so they have more settlement leverage because litigation is filed. These days, we very often are going to see a demand letter come first. The reason the bounty hunter is doing that is not necessarily because they're trying to be less aggressive. It's because they know that there is value in not publicizing the complaint. They know that the defense counsel and the defendant are thinking of this in terms of, well, how do I avoid getting something out there in public that I'm a target? You do sometimes pay more in settlement on a demand letter than you would in litigation. I've often taken the position when working with plaintiffs' counsel to say, look, you've already set us up for 2 or 3 more of these cases by filing this in federal court on an easily accessible docket. We're probably already going to have to pay some new claims to resolve whoever else saw you do that. And so as a result, we're just not going to pay you as much. Your settlement does not have as much value to us. And so it's a bit of a flip from what you often see. But what this does mean is that when you get just a demand letter, don't ignore it. It's really important to treat it seriously because 3 claims is going to cost you 3 times as much at the end of the day. We also want you to give some consideration to the accessibility of the court filings if you have been hit with a lawsuit. And most of these cases are in federal court. Obviously, federal court filings, very easily accessible, very easy to find. But a number of the plaintiff's lawyers do file in state court from time to time, not in every jurisdiction, but we do see that quite often in California. We've seen that in New York and Florida as well. States that have their own disability statutes. So in California, for example, we recently had a client who got sued out in Riverside County, where it is half impossible to track down pleadings from that docket. They're not imaged for a long time. It's really hard to search. And that's completely different than if they had been sued in San Francisco, where everything is instantly accessible, really easy to get a handle on. Case out in Riverside, we weren't too worried about copycats, but if they'd been filed elsewhere, we would have been concerned about that. In terms of settling cases, there is not a easy mechanism to get the kind of broad release you might get through, say, a class action that's going to cover everyone. Your settlements are going to be with an individual who has made a claim or sent you a demand letter, and you're going to be able to get a release from them going back in time, not necessarily going forward. But what you really want to be thinking of is, I don't want this bounty hunter plaintiff's lawyer coming after me again. But the state ethics rules are often going to limit your options there, unfortunately. There is a ABA model rule codified in California and elsewhere that prohibits a restriction on practice. It is a violation of the ethical rules even to suggest a settlement term saying that this lawyer will never sue you again. And so, unfortunately, you can't buy peace from the plaintiff's lawyer, just from the plaintiff. But there are some things that you can do. Many plaintiff's lawyers are willing to go right up to the line on what is permissible and at least make a representation in the settlement that they don't currently represent or know of any other plaintiffs that have claims against you. The actual in practice value of that provision is probably somewhat minimal, but it puts the plaintiff's lawyer on notice. You make clear to them that this settlement is intended to buy peace with you. And if you burn us and you come back in a few weeks or a month with a new plaintiff and you file a claim against us, then you're going to have a very hard time settling claims in the future, not only against this client, but with the law firm that negotiated these. And word is going to get out that you are someone who double dips, that you're someone who comes right back with a new plaintiff and files the suit. The reputational interests here are really important to the plaintiff's lawyers. They are acutely aware of what their reputation is, the expectations that folks are going to have when you get a demand letter or a lawsuit from them, and how they might harm those reputations. When we get demand letters, Nick and I both know right out of the gate, you almost 95% of the time we've dealt with that lawyer before. We know what we've settled with them before. We know their MO, and oftentimes that puts pressure on settlement values. They don't want to go too low because then next time you'll say, well, you gave me a great deal with that client, I want that deal again. But there's ways that you can use their fixation on their reputations to your advantage. And one of them is just be really clear. If you come back at us again, you're going to have trouble and word is going to get out. Now, there are a few other creative strategies that you can use in your settlement agreements. One that I really like is the notice and cure provision. Most settlements in this space are going to include a requirement to do some work on the website and remediate the website in the future. Usually the plaintiff's lawyers don't care how long you have to do that. I've had it be even 2 years, certainly a year, 6 months, totally reasonable. You can expect to get that in a settlement. What you don't want to be in a position with is the moment that say it's a 6-month period to remediate. For that 6 months, you're in the clear for that particular plaintiff, but not everyone else, just that plaintiff. And then 6 months in a day, they sue you again. What I like to do is a notice and cure provision that basically says, even after my remediation period is over, if you see a problem, come let us know, and we have a period to try to fix it. That's going to help buy you peace going forward with that plaintiff. Some plaintiffs' lawyers pay more attention than others. I have had agreements where we've created an affirmative obligation of both the plaintiff and the plaintiff's lawyer to notify us if they become aware of a violation. And that can make it very hard for that plaintiff's lawyer to come back at you with a different plaintiff. But the key thing in copycat claims is just make sure you're setting your expectations. There was a question in the chat already about what do courts say is a reasonable amount of time to try to remediate. And I think that factors in here. What I want to be really clear with everyone on is that when you settle one claim, you are not stopping everyone else from coming after you. You're not stopping someone else from filing a lawsuit the moment you settle with someone else. Certainly, you can bring down your settlement value by pointing to an agreement with someone else to remediate. The reason for that is usually these folks are looking for injunctive relief as their primary relief. And you can say, look, the injunctive relief you want is irrelevant because I already need to do this because I settled with so-and-so. But until your website is fixed, you are at risk of getting another claim. That's the reality of it. There's not really a whole lot you can do about that. And I don't think there's going to be too many scenarios where a court actually is evaluating how quickly you need to remediate. It can come up in some of the defenses, but that's not usually the framework you're going to be looking at. And finally, before we move on to the next point, in terms of reducing copycat lawsuits, it is really important, and Nick got into much of this, to make sure you institutionalize the practice of making sure your website is accessible. You need to get your creatives on board. And I've seen this with clients where there is a tension there. The creatives want a beautiful website. They take pride in the work they've done. And sometimes that vision that they have just doesn't line up with accessibility. Usually the fanciest, best, most convincing and beautiful website is the one that might be the least accessible, just based on the technology. A simple website that just, you can click through to find SKUs for products, that's going to be fairly easy to fix. So you need to get them to have sign off and think about this at the outset. One thing we often see with clients is they will hire a consultant to come in, fix the website, identify problems, and then 6 months later, they're out of compliance again because they didn't institutionalize how to make changes to their website. And so then they pull themselves out of compliance. So you need to make sure you're on top of that. And one thing as an example of this that I want to flag is holiday sales, banner ads, Black Friday, Cyber Monday. Websites will often have quick changes to their websites to advertise a particular sale or a holiday or an event. And they're up there for a few days and then they get pulled down. And there is often a proliferation of demand letters and lawsuits right after that, because those banner ads that are up for a few days, no one thought to make it WCAG compliant. And so it's just very important to be proactive. It's the best way to avoid copycat claims. And with that, Nick, you can take it back over.
Great, thanks, JP. Before I get into this next slide, I'm just going to give everyone who wants CLE the code. This is one word, no space. It's ADA 2021. That's ADA as in Americans with Disabilities Act 2021, one word, no spaces. Thank you. So this next slide, and I alluded to this earlier, we want to talk about vendor agreements and how you can reduce some of your litigation risk for website accessibility claims with your vendor agreements. And it's really a matter of negotiation typically, but sometimes you can offload at least some of this risk onto your web design vendor. And the most common way to do that is within that rep and warranty about complying with laws. I think a lot of you are probably already aware most service agreements with vendors, they contain a relatively boilerplate clause that says the vendor will comply with all applicable laws or regulations. And this is important because it relates to that indemnification provision, right? If the vendor makes that rep and then there's this lawsuit or liability or cost to your organization as the vendor's client, because the vendor didn't comply with all laws and violated that rep, well, then you can usually ask the vendor to indemnify your organization. But consider for a second the two examples of this common rep and warranty that are on this page. The first example says, vendor promises that it shall comply with all applicable laws and regulations related to the services provided to company pursuant to this agreement. Very standard rep, seen it in a lot of agreements. What does it mean? Does it mean that this vendor is promising that the website it designs for its client is going to be free of access barriers? I don't think so. To me, at most, this type of rep means that the vendor is promising that the vendor itself isn't going to violate any laws that apply to the vendor while it's designing your organization's website. And so what does that mean? That could mean the vendor is not going to, steal anybody else's IP. They're going to pay their employees, appropriate wages, comply with wage and hour laws. They're not going to, breach a trade secret theft or something like that. But I don't think that it's ambiguous at best, really, whether that type of clause gives your organization some cover and constitutes a rep by the vendor that their product is going to comply with the ADA. Consider then the second example here, which says vendor promises that its services provided to company pursuant to this agreement shall comply with all applicable laws and regulations, including without limitation, all laws and regulations regarding the maintenance and administration of company's website. That gets us a little bit closer to a place where we want to be. It's a little clearer, and it provides the organization a much stronger basis to claim that the vendor promised that the website it was designing for your organization would comply with all applicable laws. And I understand this comes down to what you're able to negotiate with your vendor during the vendor engagement process. But remember, what your organization is buying when you engage a vendor is you're paying the vendor to design a legally compliant website. So, don't be afraid to at least ask for this or try to negotiate this point, because there's a very good argument that this is, among other things, what you're engaging the vendor for. In addition, the last two bullets here, it's pretty standard. A lot of you probably already know this, but every service agreement should include a well-drafted indemnification clause, because if you don't have the indemnification, negotiating a good rep and warranty about legal compliance might not get you anything. And you should also include a duty to defend clause for indemnifiable liabilities. Those are pretty standard, but still, every once in a while, JP and I see a vendor agreement that doesn't have them. So it's a good idea to just double check, make sure your current service agreements have those. And now for our last side, before we try to maybe answer some questions, JP is going to discuss some common legal defenses to ADA website claims.
Thanks, Nick. So I'm going to talk through a couple of the legal defenses you might have. And before I do that, I want to make clear, if you are in the realm of you have an active lawsuit and you are litigating your legal defenses, you are breaking new ground, most likely in your jurisdiction. This doesn't happen very often. Most of these cases settle, and I want to make sure everyone knows that. The vast majority of these cases settle. Every case that gets litigated extensively is probably a test case of some sort to try to make new law somewhere, to push the edges of the law. And so this doesn't happen terribly often, but it certainly can happen if you have an unreasonable plaintiff's lawyer, or if you feel really strongly about your position and want to make sure that you are never going to get a copycat claim again. So the primary area of focus of the courts has been on this question I addressed earlier of, does your website need to comply with the ADA at all? That was the initial battleground for the ADA. And as I mentioned, the law is mixed and scattered. So that's the first thing you want to deal with. We saw some questions in the chat about nonprofits, about trade associations. That's where you're going to want to have your fight and make your stand, as the ADA typically is applying for Title III of the ADA is applying to for-profit entities conducting business. Trade associations, there's going to be some unique questions there that I don't want to dive directly into with a legal opinion off the cuff, but certainly that's certainly a different type of industry and business than your typical retail sale, which is where most of these claims are going to be focused. So that's your frontline defense. The second is going to be a lot of what Nick has already talked about, which is be ready to demonstrate that your website is accessible. Have reports going back before the lawsuit was filed or the demand letter was received, and have a proactive approach to developing some evidence that you are reasonably accessible. But on this point, what I want to be really clear on is that the reason that most of these cases settle is because at the end of the day, in one of these cases, the question is your website reasonably accessible? So how do you show that? You're going to need to hire an expert witness to show that. You're going to have to hire an expert witness who is knowledgeable regarding these issues, and you can walk through your website, which may have a tremendous number of pages. So that's really expensive, obviously. That cost to prove that is often going to be significantly greater than the cost to settle the lawsuit. But again, that is why these usually settle. One interesting argument that we've seen folks make some good use of is going to be the question of mootness. Your remedy under the ADA, other than attorney's fees, which is what it's really all about, is going to be injunctive relief. And so if you can really quickly jump on it and fix your site and have it remediated and demonstrate that you've resolved all the issues, you can moot the relief that they're primarily seeking. And it puts the plaintiff's lawyers in a tough spot, because then it makes crystal clear what we all already know, which is that they're litigating for attorney's fees. Judicial opinions on the question of mootness have been mixed. There's been some good news. There's been some cases that have not been sufficiently persuaded and have found that mootness is too tied in with the question of reasonable accessibility, which is ultimately a fact question. But it can be a valuable tool, and at a minimum, it can help pull down settlement values. Another issue that's somewhat related is attacking standing, the question of injury in fact. Again, this is one where there has been some mixed law. Some courts have said it is perfectly okay for someone to be a professional website checker who just spends their time searching the internet trying to find sites that don't comply. A few courts have been okay with that, but some have not been. A California state court recently was not okay with that. There's been some good rulings out of New York and elsewhere, particularly in federal courts, where the court has said, look, you aren't actually looking to book a hotel stay. You aren't actually looking to go here. There's been some cases where someone says they're blind and they're having trouble accessing a website that relates to something that is just impossible for them to do. Someone said I couldn't buy a car here. And in deposition, they had to say, well, who are you going to buy the car for? They admit, I wasn't going to drive a car. I wasn't going to buy it for anyone else. And so you've got to get pretty far into a case to prove this. You've got to get a deposition that basically says, look, I didn't really intend to go here or to buy these services. But some judges take issue with this, and that can be something that you can use to your advantage. And the last thing I'll mention is simply taking a look at offer of judgment rules in your jurisdiction. Again, because experts are so expensive in this space, if you have an opportunity to make an offer of judgment, California State Court would be a 998 offer, that creates some possibility that the plaintiff or the plaintiff's counsel at the end of the day is going to get hit with a big costs bill, including your experts. You can really disincentivize them from moving forward. This is not something we would suggest doing lightly. This is something we'd say can be saved for a really difficult plaintiff's lawyer who's not refusing to settle on any reasonable basis. I know we have a lot of questions in the chat and can't get to all of them, but one I want to jump in on is the question we received from Sean Close about what these typically settle for. That's probably the question that's most applicable to everyone that's here and watching. And the answer to that is that it varies fairly significantly. It really depends on who the plaintiff's lawyer is. There are plaintiff's lawyers that I know I can settle a case for cheap. I've had folks who frankly don't seem to know what they're doing. It's a bit of a hobby for them, and you can settle a case for a couple $1,000s. That's not the standard. The folks who we see day in, day out, there's going to be a range of where these things could settle. High four figures up to 20, 30, something like that is not uncommon. The fact of the matter is it's going to be less than litigating the case, and that's what the plaintiff's lawyers are often counting on. In my personal experience, and I think Nick would have more experience in New York, I've tended to see cases filed in New York demanding a higher payout. I think the settlement value in California has kind of taken a hit in recent years with some of the judicial opinions and has started to come down. I think in most cases, in terms of settlement, the amount it takes to pay off the plaintiff's lawyer is often less than it takes to remediate the website, but it depends. I've had cases where we settled one many years ago for an e-commerce vendor who had 17,000 products on their website with a photo for everyone, and none of it was compliant. None of it had alternative text. That was an example where for that client, that was the cost of settlement, was remediating and programming alt text for 17,000 products. Your website might be different. You might have in-house resources that can handle this, and it doesn't really cost you additional money, but everybody's going to be a little different, and I don't want to downplay the potential cost of remediation.
JP, if I could piggyback on that, and we'll try to get everyone out just a few minutes early, but related to the standing defense that you mentioned, and then also kind of related to the question we got about settlement, it does depend upon the defenses that are available. That's a big tool for negotiating a more favorable settlement. And it works hand in hand with really showing the plaintiff's lawyer that this isn't going to be an easy case for them. Most of them are not in the business of litigating these cases all the way to the end. And so by way of example, I had a client recently who got a demand letter. All this client, I won't mention names, of course, but they're in the commercial real estate business. I think that they're selling buildings that are worth tens of millions of dollars in large cities around the country and the world. And I kind of said to the plaintiff's lawyer, I said, "Are you really going to be able to show that your client was a bona fide purchaser of these goods or services?" I mean, I know I couldn't. I'm not trying to buy a $40 million office park anytime soon. So, that was a case where the plaintiff's lawyer said, "Oh, you got me." And we were able to, settle for very low in the spectrum of where these cases tend to settle. Every client is going to be a little different. Everybody's going to have a little bit better or worse of a defense, but that's where you want to, again, speak to your lawyer about what defenses are available and how can we leverage those defenses for a more favorable settlement agreement. One question I wanted to ask, because it's so relevant to this issue or answer, it was one of the earlier ones that came in. And again, we're not going to be able to get to all the questions, but we are going to push out that Q&A document next week. Someone asked, well, does the ADA apply to nonprofit websites? And that gets back to what JP was saying about the commerce element, the applicability of these laws. If it's just purely an informational site, all you've got up there is information about the charitable mission, maybe of the nonprofit, then probably not. But a lot of my nonprofit clients, they have that information, but then they also have information related to potential commercial transactions. Maybe they're selling T-shirts or bumper stickers or other merchandise, that's related to their cause. And that's where then that can be enough of a hook for the applicability of the ADA. And then even in some instances, if there's not a commerce element, depending upon what state or jurisdiction you're in, there might still be an obligation to improve the accessibility of your site. But again, that's where you want to consult with your attorney about, do we have even a defense that the statute doesn't apply to us?
There are two questions that just came in a moment ago that I want to jump into really quickly that I think are tied together and I think help me repeat what is my general mantra for clients and what I always try to tell them. And those are the questions from Mary Ellen Kleiman and Tom Hoffman, which sort of relate to what is the DOJ doing about this. I don't believe we've seen aggressive DOJ action going after particular websites. I think right now they've got some other big issues to deal with, and hopefully they're focusing more on rulemaking than actually going out and trying to prosecute. If you run a traditional business website, I don't think you're at great risk of DOJ action. If you have something unique, like let's say you're a massive employer and your employee healthcare or benefits program is inaccessible and you have thousands of employees who can't access certain things, maybe you make yourself a bigger target. But for most clients, that's not the primary risk you're facing. Nonetheless, the Biden administration DOJ is interested in this. It was an issue during the campaign that they mentioned. It's certainly something that they are going to be focusing on. And my personal opinion is that there's been some fits and starts in terms of regulation, but at some point, someday, the regulators are going to say, I think, that commercial websites are places of public accommodation, and that's going to be DOJ's opinion, and they're going to provide that advice and guidance. I don't know when that'll happen. Rulemaking is incredibly slow now, as everyone knows. I doubt that a legislative change to the ADA is something that is going to happen anytime soon, but someday I think that's going to happen. And so my mantra to clients, which I know I've said already today, but I'm repeating it because I think it's critically important, is money spent to address this issue is money well spent. You may legally be in the clear right now, but fixing your website now is going to help you later. Because someday you're going to be, on the hook in some jurisdiction for a potential claim.
So I think with that, we'll try to let everybody out just a few minutes early. Again, thank you to all our attendees. Thank you for the great questions that we received. And we will follow up soon, both about CLE, which again is ADA 2021 for the password, as well as the Q&A document for answers to everyone's questions. Thanks, everyone, and have a great rest of your day.
Thank you, everyone.